How can you want to put a person's medical situation onto the record for the public to hear? That was so unprofessional of the judge. Why are you hinting to the state that they need to charge Gwabini? To a collusion. This is exactly what they mean. But my question is, if you have full information, why is it that the same people that you took out of court the day before, you released them? When Gwabini raised this issue about the people being taken by the police, you didn't seem bothered. Now all of a sudden you want to know the nitty-gritties of what's happening with the people outside. His argument was based on a minority judgment in this particular case, which is crazy business. And now they want to come and bring Gwabini as a Section 204 in the defense's case. Njarni. Basically, guys, we are having a trial within a trial. Aguti, a trial within a trial and getting a back door, 186. Judge Ratha, if this is what you've been doing for the past 50 years of your experience, they need to go back to all of those cases where you were involved, because you are rotten to the core.
And I'm bad like the Barbie. I'm a doll, but I still wanna party. Being felt like I'm ready to bend. I'm a 10, so I pull in a 10. Like Daddy, Stacy.
Hello and welcome to my channel. If you are new here, my name is Nogwazi Ndombela, also known as Gwazi Bear on all social media platforms. Do subscribe, be a part of this family, and if you are a returning subby, welcome back, darling. Now, as you know, every week I give you the proceedings in the Senzo Meyiwa trial, so I'm here to do exactly that, and you guys already know the rules of this house. Before we get into the video, please like this video so that it does reach a greater audience. Please comment with your thoughts on the proceedings of the week, and also do super things if you can. The button next to the like and dislike button, it but with thanks, guys. Give down the channel, I would really appreciate it. December manje, December manje. Jokes, guys. If you can't super thanks, please make sure that you do watch the ads so that I do get paid via YouTube. Okay, so without wasting too much of your time, let us get into the video of this week. Guys, this week was a very short week considering that the proceedings only started on Tuesday. It was made even shorter with the drama that unfolded in court, so let's unpack. Now, when we began the proceedings on Tuesday, Baloyi basically broke down to the court what had transpired the previous week, where the state had tried to question Gwabini with regards to his statement that he allegedly made, and there was an objection by Advocate Mnisi saying that the state needed to prove this particular statement, and with that, the state then suggested that they all bring heads of arguments, submit heads of arguments, and the defense would then respond. So that is exactly what we were meant to do on Tuesday. Now, before Baloyi starts addressing the court on his heads of arguments, the judge does indicate that Ramosipile's response in his arguments is that the judge is factus officio. Guys, Latin is so sassy at this point when it comes to this case, but basically what I picked up from that is that the judge is basically trying to overturn his decision that he made when he did tell the state that they should prove the statement last week. After Ramosipile addressed the court, then Baloyi started his arguments, and briefly, I think about 2 sentences into his argument, Gwabini basically brings it to the attention of the court that there are people that have been escorting him to court, and he notices that they have been called out by the police and he doesn't understand what is happening. Now, guys, one thing about the state, they will intimidate witnesses. One thing we've noticed about this case is that it's never going to end, because at the end of the day, it feels like this is no longer about the Meyiwa family and it's about people trying to protect their jobs. So Gwabini does indicate that the people that he came with have been called out by the cops, and he is wondering why. The judge then says, well, he also doesn't know, and he seems so nonchalant about the whole situation. As they are busy discussing that, Advocate Mnisi then does stand up and say, you know, can he have some time to go and find out what is happening with Gwabini's friends? Then the court does allow this. Ngumalo does also follow. As we're sitting waiting to find out what is happening with the police outside, Baloyi does indicate to the court that there's an ongoing investigation. And I'm just like, how did Baloyi know about this ongoing investigation already? Because he wasn't part of the people that went outside to check. But he's already telling the courts, before Mnisi even comes back from the police outside to find out what has happened, Baloyi is already telling us about an ongoing investigation. Njorani, how did Baloyi know? And Now that I think about it, when he started his argument, he seemed to be a bit delayed, like he was delaying starting his arguments. It's as if they had planned that these police would walk in a few minutes when the proceedings had just begun. So when Mnisi does come back, he does indicate that there seems to be a very serious problem outside and that they would not want to put anything on record, but there seems to be ongoing investigations and they would like to address the court in chambers. Now that Mnisi indicates to the judge that there seems to be some ongoing investigations or new information that has come about in this particular case. Now all of a sudden the judge is interested in knowing what has happened. Were the people that were in court arrested? When Kwabini raised this issue about the people being taken by the police, you didn't seem bothered. Now all of a sudden you want to know the nitty-gritties of what's happening with the people outside. Ngumalo and Mnisi indicate that it's not worth putting onto the record, but they do need to consult their clients before they actually address the court on what is happening. The judge didn't want to actually adjourn, saying that they need to tell him why he's adjourning first. Why are you forcing the issue, Judge Ratha? Just let the people consult and then they'll update you as to what's going on. Like, for real? When they returned from the short adjournment, we were told that there were discussions that were held in chambers, and due to those discussions that were held, the court will then adjourn for the day. So those were the proceedings on Tuesday. We were expecting the arguments, but clearly we weren't going to get the arguments on Tuesday because of this little drama that took place. Now on Wednesday, when we returned, we expected now the arguments to commence. Baloyi then did stand and say to the court that yesterday we had adjourned due to an issue, but because of the issues that were raised yesterday, they have beefed up the security and it is safe to continue with the proceedings for today. Now guys, whilst we were watching the news and being briefed about what was happening, Linda Mnisi from Newsroom Africa does then say that there was a threat on the prosecutor's life as well as the judge. Now, the information that we had is that there were just new developments. According to Linda Mnisi, it was said that there was a plot to kill key individuals in the state's case, or in this particular case. So, and Baloyi does say that, they've beefed up security, so everybody is safe. We should be good to continue. Now, Mnisi then addresses the court and he brings it to the attention of the court that yes, yesterday we had adjourned with this issue about investigations that were happening. The state is now talking about the beefing up of security, but they're not touching on the fact that the police officer that they spoke to, Advocate Mnisi and Advocate Ngumalo, told them that there was apparently this investigation that was going on about a plot to kill key witnesses in the state's case, and it was said that the defense is actually part of the plot to kill. So it is said that the defense spoke to certain individuals that were in court, and when the defense warned these individuals that the cops were looking for them, then these people ran away. At what point did this happen? When did this happen? But what surprises me the most is the second thing that Mnisi mentions, where it said that Mnisi has a tendency of putting his head where it doesn't belong, or not minding his own business, right? Now, my question is, how is Mnisi plotting to kill state witnesses with whoever he's plotting with, but then at the same time you're telling him that he's putting his head where it doesn't belong? So basically he's also a threat. Like, please make it make sense, because it's one thing to say that Mnisi is plotting with whatever people to kill the state witnesses, but then it's another to say he's putting his nose where it doesn't belong. That's a direct threat to Mnisi, to say that you're stepping on people's toes right now with this case. The same happened with Advocate Difo, the same happened with Advocate Mngomezulu, and now we're experiencing the very same intimidation Mnisi, and it is not fair. Now, when Mnisi brings the correct details as to who is being threatened to be killed, or the plot to kill, is actually on Muhola and Kininda and a third person. Now, he says he got this information firsthand from the gentleman who says he's been heading this investigation, and he says that they have full information about this whole plot and everything. But my question is, if you have full information, why is it that the same people that you took out of court the day before, you release them? Because if you had full information, that would mean you know they're the right people, you know what plot they had, you've got the evidence, and therefore they should still be in jail. Why did you let them go? So Mnisi basically says that he doesn't take these threats lightly. These are very serious threats when they say that he's butting his nose where it doesn't need to be. And also the fact that it's said that he is part of the plot to kill. He says this has really put some strain on him, and he can't see how he can continue to represent a suspect in a case where he's also a suspect in a plot to kill. So he basically says that emotionally, mentally, he is not able to proceed with the arguments on Wednesday. Ramasipili also addresses the court on the issue where it's said that the defense is also complicit to the plot to kill, and he says that, you know, that's the information they got and that is what it is. Numalo also addresses the court on this issue, and he says that in the 3 decades that he's been a member of the court or an attorney or an advocate in the court, he has never been accused of such conduct, and it is shocking to him that this is what is going on in this particular case. Nisi then indicates that he requests the court to adjourn until the investigations by these particular officers is complete and that his name is cleared from this plot to kill, and he's unable to proceed with the proceedings. And Judge Ratha basically says, you know, an investigation can take 20 years. So does that mean that this case will stop for 20 years? That's not possible. I'm ruling that we need to come back and we need to, you know, do these arguments. Nisi then says, well, mentally I'm not fit. I'll need to go consult a doctor. I need to just fix myself up, but I'm not prepared to continue with the proceedings for today. The judge then says, how long will it take for you to talk to a doctor and come back? And Nisi says, well, basically I can't make those arrangements to see a doctor at the moment because I am in court. So I will make the arrangements, see a doctor, and then we'll see how we can proceed. The judge then rules that the proceedings will continue on Thursday, where the arguments will be put on record by both the state and the defense. So we adjourned yet again on Wednesday with nothing happening in the courtroom. Now, finally, on Thursday, we came back, third time lucky, and we did then indicate that the state then indicated that they are ready to proceed. However, Gwabini was not available. Nisi then addresses the court and tells the court that Gwabini has sent a medical medical certificate to say that he's unwell and he's unable to attend the court proceedings. And basically that he will be ready to proceed on Monday. The court then asked Umnesi what is wrong with him. I mean, how can you want to put a person's medical situation onto the record for the public to hear? That was so unprofessional of the judge. The judge then also made a comment that people buy medical certificates, almost insinuating that Uzungu is not sick and he's faking it and he went to go buy a medical doctor certificate. So he decides to read the medical certificate onto the record, and now we all know that Gwabini has migraines or headaches. And I'm just like, Judge Ratha, that's not how you conduct yourself in a courtroom. In fact, that's not how you conduct yourself ever. Guys. Like, I was so disappointed with the judge's behavior, but when am I not? Judge Ratha says, well, Gwabini is not here, so what is the state's view on this? Baloyi basically says that the judge had ruled that Gwabini needs to be present for this argument, but, you know, if he's not here and everyone agrees that it's okay that he's not here, then we can proceed. Nisi then says, you know, he doesn't see a reason why Gwabini needs to be here because he will have no contribution to the arguments in any case. They can be interpreted to him when he does return, and we can then proceed. Ramasipili agrees to this, and so does Umumado. The judge then says he begs to differ because Gwabini is a witness and he needs to be here, but however, because of the drama that has already taken place this week, he will then allow the state to lead its arguments with Gwabini not being in the box, and then the arguments will continue as planned. As the judge is busy addressing the court with the issue of Gwabini, he then hints to the state that Gwabini should be charged. Judge Ratha, if the state feels that Gwabini is turning against his Section 204 statement, they should figure that out on their own. Why are you hinting to the state that they need to charge Gwabini? We are to a collusion. this is exactly what they mean. Baloyi then starts with his arguments, and he basically points out where this whole issue began, and he does quote some authorities, one of which stood out for me during his arguments is the one of Makala. And it stood out because when the defense responded to the state's arguments, they broke that Makala case down. Like, I loved how they did that. But Baloyi basically, in his arguments, I didn't hear anything about him quoting any authorities where it was allowed for a state to lead or to cross-examine a witness, considering that the witness hasn't proven, or considering that the state has not proven the particular statement. He never quoted anything on that, but all he did is basically go through the evidence of Gwabini, go through the evidence of Uzungu, go through the evidence of Ukininda, and how Uzungu was scared for his life, and how that's the reason why he didn't come to testify, and all those things of that sort. He also does point out that when Kininda came to testify in court, he said that the presence of Constable Zungu at Phosphorus was actually introduced by Ukwabini through his statement. Now, the funny thing is, although we don't know what Kwabini's statement actually says, but the funny thing is that when Kwabini testified, he said that he told Abo Kininda to take whatever Muzi said and put it in his statement. I don't remember Muzi mentioning Kwabini, so how did Kwabini's statement come about? I would actually love to know. Now, as I said, during the state's argument, it did point out a case of Makala. And in this case, it basically says that there was a minority judgment. So basically, his argument was based on a minority judgment in this particular case, which is crazy business. Now, he does say that he thinks that he should be allowed to cross-examine this particular witness on the statement because it's in the interest of justice, it's in the interest of finding out the truth. He then does quote Abo Hepworth. Hepworth is a very popular authority in this case, and also R versus UFJ. He does emphasize that it was a minority judgment at that case. So after Baloyi led his arguments, which was a very whack argument if you ask me, because I got nothing out of that argument from Ubaloyi, but he does say that he is complete, he has completed, and then we go on a break before Advocate Mnisi presents his arguments. Now, Umnisi stands firm on the fact that he needs Baloyi to prove this statement. He says that the state mentioning the issue of Gwabini being fearful for his life is neither here or there. He also does mention the fact that the state keeps emphasizing that Gwabini is a Section 204 witness. Mnisi says the fact that the state didn't call Gwabini when they were leading their case, Gwabini can no longer be a Section 204. In fact, he's no longer a state witness. So the defense has taken this witness that was disregarded by the state, and they have picked him up, they've brought him to court to come and tell the truth. And he does also emphasize the fact that Gwabini being here, he's not actually a defense witness. He is a witness that was not used by the state, that the defense felt would be helpful in their case. He then says he did think that the state would come with some new authority or some authority that would back up his application, but all the state has done is quote the evidence of Kininda, quote the evidence of Zungu, which is already on record, and he doesn't understand why. He mentions that the state is actually leaving out important information in their argument when they say that Gwabini says that Gwabini made the statement voluntarily, because Gwabini in his evidence said he had been tortured. And because he had been tortured, he then said, take whatever is written in Muzi's statement and write it here and I will sign. But the state failed to mention that, and that is because it is a serious problem, the fact that Gwabini mentioned that. But the fact that the state doesn't put that in its argument, it says that the state is hiding certain information and they're not being truthful to the court in their argument. Mnisi even reminds the court that the state saying that the defense has already introduced the statement or has led the statement is not true, because what Mnisi had done is that he had taken Ukwabini through how a statement should actually be done or should be taken. And he even says, remember, Judge, you even told me that I'm cross-examining my own witness. And I told you, no, I'm not cross-examining my own witness, but I was asking this witness, was this process followed for it to be considered a statement that he wrote? And he did indicate that that was never followed. Now, when Mnisi addresses the issue of the Makala case that the state kept referring to, you could tell that Mnisi knew this case very well, because he broke it down step by step as to what happened in that case, and that case got a ruling. The ruling was taken to the Supreme Court, and Supreme Court got a ruling. They were still not happy with the ruling in the Supreme Court. Then it was taken to the Constitutional Court, and he says at the Constitutional Court 9 judges sat in that case and only 3 were dissented, which is the 3 that Ubaloyi keeps quoting, minority. And he says, but at the end of the day, the Makala brothers were acquitted. And therefore, what the state is quoting here is irrelevant. Now, Mnisi goes on to mention 2 other cases. It's Moses versus S, as well as S versus Govender, where he says that, the process of a statement is referred to in this on these particular cases. And it said that when you're taking down a statement, it's written down, you read it back to the person, they confirm the correctness, they sign, and then they identify the signature, and then once that's done, that is when the states can then continue leading the information about the statement. Now, the part where I was just like, Mnisi is so done. Mnisi is so done with the states and his shenanigans. He says that, so this thing of bringing arguments, we could do it from January to December, we could do it from sunrise to sunset, but it doesn't get us anywhere. The state needs to prove the statement. He also then emphasizes the fact that Gwabini does say that he was assaulted, and the fact that the state doesn't mention that is omitting evidence from the court, and it's very suspicious that the state has done that. Then Mnisi addresses the issue of Gwabini fearing for his life, where he says, there's no way. Through the evidence of this particular witness, we can tell that there's no way that he feared for his life, because he went back to the state's offices 3 times. 3 times did he go to the prosecutor's offices to try and come and testify. And he even says the 3rd time, he even got himself an Uber and was right at the doors of this courtroom. And he was turned back by Umukhola. Mnisi even says, I can just imagine how Mukhola was chasing him away, saying, go, 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 go. He then says he doesn't feel that it is good that we are embarking on a trial and error when it comes to this particular case, because these accused are not guinea pigs for us to be trialing and testing new things or new methods of doing procedure. Now, as he was about to close with a bomb, he says, I can see that the court already gave Ubaloyi the benefit of the doubt by allowing him to bring these arguments. But the bottom line is that Baloyi needs to prove the statement. And if the court allows Baloyi to cross-examine the witness on the contents of the statement without him proving it first, it would be a mockery of this particular case. And he says there's no exception to the rule. Baloyi just needs to prove it. So the word of the week is prove it. Ramusipili also addresses the court after lunch on Thursday, where he also says he did prepare some arguments. And what I found so annoying about when Ramusipili was presenting his arguments is that the judge kept interrupting him. He kept interrupting him. It's almost as if the judge already knows that Ramusipili gets distracted really easily. So he interjects, he asks questions, he goes all the time. It was so annoying to witness. But Ramusipili was not shaken by that. He continued to present his argument. And some of the things he also touched on is the case of Makala, where he says it's irrelevant. And also he argued a lot on the fact that the state is saying that the defense needed to follow a certain procedure if a witness that they're bringing in already has a statement. And Ramusipili's argument in this is that we don't really need to refer to the statement when we're bringing in this particular witness, because he's here to testify viva voce. Viva voce. These Latin words are coming like this, like teen around. Okay, so he says he is testifying, so it's word of mouth. The statement they don't really need to refer to because this person is here in person to give his testimony. One of the cases or authorities that Ramasipile mentions is the Mafaladiso and others case, and he says that this statement hasn't been proven. And then the judge says, so was their statement taken? And Ramasipile says, well, it's the state that alleges that the statement was taken. So in our response, we're responding to what they have told us. Clearly puts it to the judge that the witness has said that he never made a statement, but the state is alleging that there is a statement, so that is why the arguments are in such a manner. He then says that the objection by Advocate Mnisi in this case was not trying to bar the state from cross-examining the witness. However, they were saying, prove the statement first before you can actually cross-examine. Then the judge asked the question, just for my understanding, how does the state then prove a statement when the witness is saying they never made it? Ramasipile says, you've actually answered yourself. You've answered the question. I can actually literally sit down and fold my arms because that's exactly where I was going. If the state is unable to prove because the witness is denying the statement, then it ends there. There's nothing more for the state to actually dig on. There's nothing more for the state to actually cross-examine on. It ends just there. Ramasipile also says he doesn't know what the state was getting at with the Makala case because the Makala case is totally irrelevant to this particular case that we're dealing with here. Now, the highlights of Ramasipile's argument for me was the point where he said, Kwabini, when he came to testify, said to this court that when Kininda and whoever was in the room at the time spoke to him about a particular statement of Moses Miya, he said, take what is in Moses Miya and write it down and I will sign. And then he says, this should tell the court that this statement is not Kwabini's statement. And I was like, you're done, Ramasipile. You're done, because if that he said, take that and put it there, that's not a statement. That's not how you conduct a statement. That's not how you get a statement from a witness. He says that the state had a particular strategy that they were working on and they used that strategy, and now that the strategy is backfiring on them, they want to now come and change and want to introduce this information through the back door, literally. And he says that the state also mentions the Hepworth case onto their arguments, but the Hepworth case basically says when there's a legitimate omission. But in this case, it was a strategy that they used to omit this information or to not call this particular witness, but now they want to cry foul. Now, when Ramasipile mentions Hepworth, the judge then goes into the section of Hepworth where it talks about a judge just not being like a referee, but he's also there to find as much information. He needs to collect all evidence, and he keeps emphasizing that fact. That's when I knew that the judge is considering this little application of Ubaloi. Then Ramasipile, to actually shut the judge up, he says, we can argue until we're blue in the face. But it doesn't change the fact that on Tuesday, before the shenanigans that went down, the judge had ruled that Baloyi needs to prove the statement. So, prove it. Ramasipile with that then concludes his arguments, and then Advocate Ngumalo does also say that he also prepared some arguments, and he says, just to be clear so that the judge doesn't interrupt him, this is an alleged statement. There was no statement done by this witness, but the state alleges that there was a statement. The judge even asked, who alleged that there was a statement? And Ngumalo says it's the state that alleges that this witness made a statement. The first point that Ngumalo does make is that when Constable Zungu came to testify, he was cross-examined in detail by the defense. The state indicated, because the person who was pinnacle to Zungu's evidence was Ukwabin, right? The state did indicate that they will be calling Ukwabin. So now the state has closed their case and they never called Ukwabin. But now they still want to refer to Ukwabin as a Section 204 witness. Ngumalo, there was a point that he made on the day where he said, the state hasn't led any evidence that says Ukwabin was complicit to the planning of the death of Senzo Meyiwa, or he was involved, or he was an accomplice. They've never led such evidence. So how is Ukwabin a Section 204 witness? Ngumalo refers to two cases, S versus Gently and S versus Heslock, if I got those names correctly. And he says, you know what? evidence needs to be corroborated, right? And Zungu's evidence is not corroborated in all material aspects. It's not corroborated at all. He also addresses the issue of Gwabini fearing for his life, where he says the fact that Gwabini came all the way to court and was turned away by Umuhola, as according to his evidence, it's proof that this person is not fearful for his life. In fact, he is insisting that he does want to come testify and tell the truth. Where I noticed that Nxumalo touched a nerve with the Judge Ratha is when he mentioned Kininda, where he says, Kininda also came to testify here, and nowhere in his testimony did he mention that Gwabini was arrested in connection to this case or whatever the case might be. And Judge Ratha then says, then how did he get the statement? And Nxumalo is like, we don't know, because that evidence was never led. And then Judge Ratha asked the question, but when was he given the opportunity to tell us all of this? And Nxumalo says, when the state was leading him during his evidence in chief, he could have told us that Gwabini was arrested, he was an accomplice, whatever the case might be, but he chose not to do that. And now they want to come and bring Gwabini as a Section 204 in the defense's case. Njarni. Nxumalo then emphasizes the fact that the state needs to lay proper foundation first before they can cross-examine this witness on the particular statement. And he says that a person is referred to as a Section 204 witness when they are called by the state. And the fact that the state did not call this witness, he cannot be referred to as a Section 204 for the defense. Like, how does that happen? He says this like in the sense you cannot invoke the Section 204 on the witness when he's on the stand for the defense. Now this just proves that what happened in court last week when Ratha warned the witness about Section 204 last week, when he read the whole Section 203 and Section 204, Ratha was wrong, and Nxumalo was pointing that out. Invoke Section 204 witness defense, you can't do that, but Ratha did that last week. So Nxumalo was basically saying, hey, we see you've done the wrong thing here in this procedure, but it is what it is. What I liked also about Nxumalo is he says that the fact that we're bringing arguments here has not ventilated the issue that Ubaloyi needs to prove the statement. Also, yes, we've brought the arguments, we're arguing, but it has not ventilated the issue of what? Of Baloyi proving the statement. Then Nxumalo says the state's comments or remarks about the defense not using the 204 or the Section 190 are regrettable because they didn't call Gwabini, so now Gwabini is theirs. He then also touches on the issue of the Makala case that the state had referred to, where he says the Makala case that the state keeps referring to was overturned in the Constitutional Court, so therefore it cannot be used. And then he points out that the fact that the state is requesting for a trial within a trial, it can't be, because they want a trial within a trial for a Section 204 witness when they didn't call this particular witness as a Section 204. Like, it cannot be. And Nxumalo pointed out something very, very important, where he says that the state had two mechanisms that they could have used, but they didn't. The first one is to call Uzungu as their witness, a Section 204. In their case, they didn't use that. Or to call Uzungu as a witness and then use Section 190, where they can say Uzungu is a hostile witness and he's changing his evidence. They didn't do that either. They failed to use those two mechanisms, and now they want to cross-examine this witness on this particular statement. With that, Nxumalo then concludes his arguments, and Baloyi does say that he does just want to respond to two aspects. One of them being that Ramsipili and Umnisi said that when Kininda spoke about the issue of Gwabini being fearful for his life, Ramsipili and Nxumalo referred to that as hearsay evidence, and Baloyi basically says that it isn't hearsay evidence because Kininda had first-hand information. He heard the information from that person. And then the second thing that he wanted to address is the issue where the state, where they're saying that the state didn't lay a foundation, this particular statement. And Baloyi basically says, no, the bottom line is that this is what Gwabini said in his evidence, and therefore that means that the statement was made. What statement? The statement was made at Primrose. What statement? What statement was made at Primrose? Information we finding up. Statement you literally took information lab. Our core statement that Gwabini made, like quite literally. So those were the proceedings on Thursday. The judge then said we would be adjourning and we would return today, which is Friday the 5th of December, to continue with the proceedings, and we can hear the judgment or the ruling by the judge. Now, I did have a bit of difficulty listening in on the proceedings today, simply because SABC's sound was whack and I missed most of Ratha's ruling. But from the point where I picked up, I could tell that Ratha was literally opening the state's case kabusha, brand new from the box, something that I've never seen happening in my life. Now, Judge Ratha does say that, he needs to hear all this evidence, and then he says that he's invoking a section 186. Tell me why Judge Ratha, instead of making a ruling on the application that was made by the state, is he reopening a case and wanting to call witnesses? Please tell me why. He says that because of Gwabini's evidence that he was assaulted, he wants now all the cops that Gwabini says were there to come and get cross-examined. Judge Ratha, if this is what you've been doing for the past 50 years of your experience, they need to go back to all of those cases where you were involved, because you are rotten to the core. To try and justify the nonsense of a ruling that he's made, he says the defense has a right to cross-examine all the witnesses that I'm going to call. But there was a question that was asked by the defense, and you could tell that the defense is just confused by this ruling. Numana says he's a bit confused. What is the ruling on the application? Because the arguments were on an application, but the judge comes with a section 186 to call other witnesses. Other witnesses for what? We were dealing with proving a statement. Why are we calling witnesses? We were dealing with proving a statement. The state is meant to prove the statement. The judge is meant to make a ruling on the arguments of proving the statement. The judge comes and says 186, I'm calling witnesses. Guys, I was just as confused as the defense. The defense, you could tell they were confused. Umana says, so are we holding a trial within a trial or what? And he says, no, it's not a trial within a trial. But technically, you are having a trial within a trial to determine the admissibility of the said statement when the issue is to prove the state. Jesus Christ, Mary and Joseph, Judge Ratha recalled Umumalo just saying, but then what does that say about the ruling with regards to the state's application? And he's like, no, it stands. It stands. What stands? What? Then Umumalo asks, when does the judge intend on calling these witnesses? He says Monday. And then everyone is like, no, but Gwabini hasn't finished testifying. Gwabini still understand. What do you mean Monday, new witnesses? And he's like, listen, the law says this. And one thing about Ratha, the minute he starts saying, it's not me who says this, it's the law, you must know that it's going down, okay? Chapo, Umumalo then says, Ramasipila says, okay, Gwabini still understand, then what happens? Judge quotes again the case. No, the court is allowed to call any witness at any time. It's not me who says this, it's the law. Then Ramasipila says, but we're still leading our case as the defense. What if we have other witnesses that will testify that they were also assaulted by the same cops? Does that mean those cops will keep coming back? And he says, yeah. Please tell me why the same mentality, the same rule was not applied by the judge when we asked for Constable Zungu to come back. Why did he not apply the same mentality? Why did he not apply the same energy when we asked Zungu to come back? Now he's saying if the defense has other... So basically, Gwabini needs to be on hold. He'll call these witnesses, Oma Pumulo, Kininda of all people, because the favorites are Judge Ratha. He'll call Kininda again, and Kininda needs to come explain. Basically, guys, we are having a trial within a trial. Aguti, a trial within a trial, and getting a back door, 186. Ramasipili then points out that, but Gwabini's assault has nothing to do with this case. It has everything to do with the possession of firearm. So why are we doing this? And the judge is like, hey, it said that Kininda forged a signature, so Kininda must come and explain himself because that is defeating the ends of justice. And then he goes on to mention in the cold drink, cold drink, and I'm just like, so you know and believe that police take each other, but you don't believe that police can assault people. What the hell? Bottom line, guys, that is the decision that Judge Ratha has come up with. Instead of ruling with regards to the application by the state, he has decided to do a trial within a trial via 186. So he's calling his own witnesses, Lord knows for what, because calling his witnesses doesn't prove the statement. Calling his witnesses to testify about the assault does not prove the statement that Baloyi needs to prove. But anyway, it is said that it is recess, so proceedings are coming to an end for the year. So we will then continue on the 19th of January, and that is when all these witnesses that the judge has called or has summoned to court are gonna come. Guys, I'm flabbergasted. Like, I don't even know how to express myself at this point because I'm in disbelief of what happened in court today. I'm in disbelief. And there is a gentleman that I follow on X that always posts like a lot of legal stuff. And I'm going to post what he put on his X just immediately after the proceedings over here. And I was just like, valid. Like, you're shocked. I can't even. Like, the defense, I even said, hey, but it defense your titties. Like, what's going on? It's the shock for me, guys. It is the end of the proceedings for the year. Hopefully we will continue and everyone is still alive when we come back in January. This will be the last video from me for the year as well, because no more proceedings, no more videos for me. So ngizanibona in the next year. I hope that everybody does have a Merry Christmas and a Happy New Year. Nibe safety, guys. We'll see you in 2026.